Hello Biafrans and lovers of freedom all over the world. Good morning, afternoon and evening, depending on where you're connecting from. More updates are reaching us from the office of Barrister ALOY EJIMAKOR, the legal special counsel to our leader, Onyendu Mazi Nnamdi Kanu. The current situation on Mazi Nnamdi Kanu, detention and trial have time limits, by ALOY EJIMAKOR. It is no longer news that Mazi Nnamdi Kanu's case was improperly off the Abuja court docket for almost 5 months from the 24th of September 2024 until the 10th of February 2025 when the infamous hearing without jurisdiction was conducted in the case, triggering an impasse that has prompted a lot of people to ask, what is the way forward? Well, below are some of the answers. Given the present scenario that every judge, other than the recused judge, in the Abuja division of the Federal High Court is reluctant to handle the case, the next lawful thing to do is to transfer the case, willy-nilly, to any of the Federal High Court divisions in the southeast, especially since the charges levied against Mazi Nnamdi Kanu are alleged to have either occurred in or had impact in southeast as contrasted with Abuja. To be sure, this very fact alone endows a far superior, and arguably exclusive, jurisdiction on the Federal High Court divisions located in the southeast in line with Order 49, Rule 3 of Federal High Court Rules, Section 45 of the Federal High Court Act and the celebrated case of James Ibori vs. Federal Republic of Nigeria. Thus, transferring the case to Southeast will cure the questionable institution of the case in Abuja, which was done on the wrong purport that the Terrorism Prevention and Amendment Act, an inferior legislation to the Federal High Court Act, conferred universal jurisdiction on the Abuja division of the Federal High Court. So, now that the famed Abuja division has failed to rise to the occasion, it is time to abandon this fallacy, once and for all. Conversely, if there is some sort of an official reluctance to do the lawful thing by having the case conducted in Southeast, then it should be discontinued forthwith, because you cannot keep Mazi Nnamdi Kanu in an endless limbo while he endures a horrendous detention, awaiting a trial that has become a mirage and a subterfuge for incarcerating him without conviction. In other words, considering that the trial has stalled to the extent that diligent and timely prosecution has hit a logjam, it will offend the Constitution to keep Mazi Nnamdi Kanu in detention awaiting a trial that will not happen in the interim and even in the foreseeable future. For avoidance of doubt, the best practices of the common law adversarial system of criminal justice mandates that when a state has an insurmountable difficulty in putting a detainee on trial within a reasonable time, the next responsible and lawful option is to free such a detainee on bail until such a time his trial can be conducted properly and lawfully. To do otherwise will amount to turning such a detainee to a hapless victim of a false or an extrajudicial imprisonment by the state. Under the Constitution, every criminal suspect, especially a detainee, deserves to be tried within a reasonable time, not an indefinite time, and certainly not to be subjected to detention for almost 4 years awaiting a trial that never happens for no fault of the detainee but of the state. In particular, the Administration of Criminal Justice Act prescribed a speedy trial for every criminal suspect, and it becomes much more urgent and compelling when such suspect is in detention, and a lengthy one to boot. There is no gainsaying that from the very inception of this case, the ball has been exclusively in the court of the federal government. Mazi Nnamdi Kanu does not possess any legal duty or the capacity whatsoever to schedule his own trial. It is those that accuse him that are constitutionally burdened with that duty, and they must discharge it without inordinate delay and in strict adherence to the dictates of the Constitution. Therefore, since the federal government has proved unable to bring Mazi Nnamdi Kanu to a proper trial within a reasonable time and in comportment with the Constitution, then the next best thing, which is also lawful and constitutional, is to end this whole saga by promptly releasing him through reinstatement of his improperly revoked bail, or by a well-considered discontinuance of the case. To be sure, most will agree that this case, which was more political than legal from its inception 10 years ago in 2015, has now dangerously morphed from a pseudo-prosecution to a clear case of an indefinite persecution, such that Mazi Nnamdi Kanu is no longer an awaiting trial detainee but a ranking political prisoner of the worst kind. This is unacceptable because detention and trial have time limits set by law.